नमस्कार दोस्तों. Our today's topic is death penalty, or we can say that capital punishment. Why are we discussing this topic? Because this is in news in May 2022 that Supreme Court Sumoto opened a case for review that the process by which court awards the death penalty. Means Supreme Court had sumoto opened a review by which court awards the death penalty to any accused. So let us see what is death penalty. It is defined as a practice sanctioned by law whereby a person is put to death by the state. By whom? By the state as a punishment for a crime. Punishment for a crime after a proper legal trial. What is all keywords in this definition? That it is a practice sanctioned by law whereby a person is put to death by the state as a punishment for a crime after a proper legal trials. So here to avoid a death penalty, proper legal trial is necessary. Now let's look at what is the issue of death penalty in India and what Globe is saying about it. There is a debate whether state has power to give death penalty to any people to execute or not. So let's look at how uh, what what is happening in India and the globe. First, if we talk about India, by the end of 2021, 488 prisoners, 488 prisoners were on the death row in India under serious offences without introduction or proposal of more laws in death penalty. Okay, now then. And apart from this, several states introduced new laws which amounts to, and in these laws, though they have capital punishment as one of the punishment, like Punjab and Madhya Pradesh introduced death penalty for causing death by spurious liquor. If someone died due to spurious liquor, the one who sold or made this liquor will be awarded the capital punishment. So, in one sense, India is promoting the capital punishment. However, what is happening in the globe, some countries, means major chunk of countries, like 108 countries, have abolished it. They completely abolished it. Some countries had abolished it for ordinary crimes, only for ordinary crimes. But they retained it for heinous or serious crimes. Some countries have abolished it in practice. In practice means they will not do execution at least for 10 years. And some countries, like 55 countries, have retained death penalty, and India is one of them. So this is the scenario of death penalty. Now let's talk about the framework. What is framework? What framework? The procedure or the process or by which death penalty is avoided in India. So let's first talk about what all provisions from which the death penalty is avoided. First and foremost, we have Article 21 in our Constitution. It says that no person shall be deprived of his life or personal liberty. No person shall be deprived of his life or personal liberty except except according to procedure established by law. Means he can be deprived of his life or personal liberty by procedure established by law. And for that, we have laws made like in seventh schedule, the criminal law and criminal procedure comes under the concurrent list. Since it comes under the concurrent list, so union and state made various laws, like we have seen recently that Punjab and MP made laws for death penalty as a punishment. And let us look at some common laws like IPC 1860 talks about and have some punishments prescribed as a death penalty. Narcotics, Drugs and Psychotropic Substance Act 1988, Army Act of 1950, similarly Air Force Act of 1950, Navy Act of 1956, Commission of Commission of Sati Prevention Act 1987, SC/ST Prevention of Atrocities Act 1989. These are few acts which prescribes death penalty in India. Now, Supreme Court devised a framework for issues for avoiding death penalty or capital punishment. So, in 1980, in 1980, in Bachchan Singh versus State of Punjab case, Supreme Court upheld the constitutional validity of death penalty. So, and beside upholding the death penalty, court also initiated a framework to decide to whom the death penalty should be given. So, it gave birth to rarest of rare cases doctrine. So, death penalty will only be awarded in those cases which are rarest of rare. But who will decide these rarest of rare cases? Obvious judge. So here this doctrine is very subjective. So this is one issue with this doctrine. Now, in 1983, Machi Singh versus State of Punjab, Supreme Court gave some guidelines to decide the death penalty, and in those guidelines, suppose some crime is committed. So there is need to identify the manner in which crime was committed, the motive of the crime, the nature of the crime, and the magnitude of the crime. Beside that, whoever is committing the crime, the personality of that victim will also be taken into consideration. Means if he is first time committed that crime or he is a repeated crimer, so need to take into all these factors into account before deciding the death penalty. In 2014, the Shatrughan Chauhan versus Union of India, Supreme Court said one important thing, that inordinate and unreasonable, inordinate and unreasonable delay in what? Execution of death penalty. This delay will amount to torture or a ground for commutation. Ground for commutation. What do you mean by commutation? Commutation is altering or changing the nature of the punishment to a lighter form of punishment. So here we are changing by delaying, we are changing the death penalty in some lighter form of punishment. So this is about the scenario of the death penalty in India. Now let us take the arguments. What sort of arguments that favors the death penalty? The arguments that says that we should retain the death penalty. So first and foremost, that it creates the deterrence. It creates the deterrence. Deterrence means it creates the brutalizing effect on the society, that if someone commits that crime or such kind of crime, that he may subjected to that penalty. Here is an international example in Japan, where in Japan approximately three prisoners are executed per year. Three prisoners are executed per year to reinforce the belief of bad things happening to those who do wrong. To set an example, in Japanese society, they execute at least approximately three prisoners per year, to convey the message that the bad things happen to those who do wrong. So, first is this. Second, retribution or retributive justice. Here we talk about John Locke, who said that if someone violates another's right to life, they forfeit their own right to life. Means capital punishment is just a form of retribution as people guilty. of associated crimes to be punished. So this is this will give a sense of psychological closure to the family of the victim that, oh, the one who committed wrong or committed crime with us get punished. So a sense of closure, or we can say psychological closure, will give to the family and the loved ones of the victim. Now, the principle of proportionality. It says that the amount of crime one committed, the punishment should be in that proportion. So, seriousness of offense will decide the amount of penalty. And if you committed more heinous crime, you may subject it to capital punishment or death penalty. Now, there was one survey conducted in 2012, that survey nearly 70% of Indians 70% of Indians favored that the capital punishment should be continued. So will of citizen in India is also in the favor of capital punishment. It also incentivizes police that if someone is criminal today, someone is criminal today, he may become harder criminal, or after getting out of jail, he may commit more severe crimes, so that one who commits the heinous crime should get the death penalty. Now, these are the arguments in favor. Now, let us consider the issues or arguments against the death penalty. First, while deciding the death penalty, there is lack of objectivity. It means it is totally discretion of the judge that whom should give the death penalty. Now, second, lack of procedural fairness. Same same thing in different words, discretion of the judge in interpreting the rarest of rare cases. Again, the media pressure to give instant justice is one of the issue that dictates the community's collective conscience. Again, our criminal justice system, there are lot of lacunae in our criminal justice system, and also lack of resources and ineffective prosecution also may lead to wrong or falsification or framing a wrong person in the charges. And fifth, the long delays in trials, appeals, and thereafter executing the clemency. So there are huge delays. So these are some general issues with regard to death penalty. And also here we see that, and also here we see that no statistical proof, no statistical proof that death penalty is the biggest deterrent. We can see that the cases is increasing day by day. The crime is increasing day by day. We can quote from NCRB data or MHH data. So there is no statistical proof. Again, we talk about the retribution. There is no constitutional value of retribution in a civilized society, as we can't say that an eye for an eye is good thing in society. If someone poke your eyes, it doesn't mean you should also poke his eye. It may make whole country or whole world blind. So this is also the argument for retribution is invalid. And the morality of death penalty means there is a question of morality that if nature or in religion that God gave us birth, then who are you? Means who are you? To whom? Humans. Who are you to take my life? Who gave the right to take my life? The right is with the nature, the right it is with the God. Many religious texts prescribe that God has created us, God only has the right to take us back or call us back. So there is a principle of morality. Now, as if we support the death penalty, it will also justify torture by the police and privacy violation or other unethical practices. If we can if we favor death penalty, then we should also favor the torture. It is if someone is committed crime, he should give death penalty, should be given death penalty. Then it is normal that police can beat him in custody. So this is one issue. Now also the rehabilitative, rehabilitative or restorative justice is got sidelined with death penalty. Means we we do not give any chance to the crime who committed the crime to be reformed, to be reformed. So we we see that in societies where education and socio-economic conditions are high, their crime rate is their crimes are in declining phase. We can quote one example that since 1992 in India, there is decline in the murder rate, decline in the murder rate from 4.6 lakhs per year to 2.7 lakh in 2030. So this is the decline. What we can relate this with the education or upliftment of the socio-economic condition. Now, whether we should retain it, the death penalty or not, this is a matter of debate, and this debate is still continuing. Now, what could be the way forward? So, first of all, there should be a fair justice. How can we ensure fair justice? By resolving the issues with our laws, by ailing our criminal justice system. First, we should complete the trial in time-bound manner, do prosecution in proper manner, do not frame in false cases. Also, the lacunae in our criminal justice system, a police system. First, we should need to do that. Now, also, the we should more focused on restorative and rehabilitation aspect of the justice, because we can quote here the example of Tihar jail when Kiran Bedi was the in charge. She initiated many reformative or initiatives for the prisoners, and there the impact of that was seen quite big. Also, in Tihar jail, there is one program that they provide skilling or skill development to the prisoners and use that skill to commercially produce those products, and these are sold in our real world outside the prisoners. It will give them not only the livelihood or sustainability or income in the prison, or also when they come out of the prison they have one option to start their life. Otherwise, they what they will do if they don't have skill, or they were in the criminal environment in the jail. After coming out, they will commit crime. Now, also, what can the or what more can be done? We can talk about the mercy petition. Mercy petition should be disposed in time bound manner. So, first and foremost, we should improve our justice system and we should deliver the fair justice. And we need to bring the procedural fairness, procedural fairness and objectivity while applying the Bachchan Singh test, means the rarest of rare doctrine. So this is all for the today, and this is not the end. You should think and find more examples, more content relating to this death penalty and should incorporate in your notes and answers. So, see you till the next topic. Thank you.